Hey guys, and welcome to today's video. Today, we have an update to a sovereign citizen that old squishy gardener, Colin, and I have been following for a while. So let's begin.
Mr. Leffers, I know, I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is I'm going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hartel. So, Mr. Leffers, we're already past noon.
Sir.
So what I'm willing to do is, do you think you can state what you want to state within will 5 minutes be enough time?
I will do my best.
All right. So I show we're at about, well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06. And it looks like they're synced up with each other. So go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable. Your Honor, I am Phil Levers, lawful representative of the estate in question. I want it on the record. Y'all don't have jurisdiction. I voluntarily appear in this court today on special appearance.
So, you're making a special appearance. Is that why you're wearing your special overalls today? And I'm sorry, but if the court doesn't have jurisdiction over you, then what exactly are you doing there other than making a fool of yourself?
I move the court to take judicial notice of the Michigan Constitution as ratified without subsequent amendments in the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. The request that I've supplied, which I have to amend, because now there are extra things added. And Mr. Champion also and RJ at the defender's office refused to allow us evidence. So I'm still being denied due process. Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter. I am invoking my Sixth Amendment right, as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins and implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance. If you want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration, or pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court.
Okay, all right.
On a federal indictment, which as a national, we're in different jurisdictions, sir.
I hate to break it to you, but the Supreme Court of the United States only hears about 60 to 80 cases, and that's per year. So I don't think they're going to make a priority to hear the case of underscore McDumpfuck and his idiot wife.
So I understand you want to represent yourself. I have a couple questions in that regard. So first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things. Most recently about my hometown, the past 2 judges have been removed by the tenure council. So Canon 1 through 5, and D, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardians of our liberties and the constitutional right. So when someone pro se makes a mistake, and even unpro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So Canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay. So I will do the best I can. I am very different since dying, coma, botched surgeries. I'm a permanent head trauma case. My short-term memory is gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said, it is worthless to waste brain power on things that you can write down.
So, so as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all 3 parts here. So
I watched your videos while you were a judge. I watched the one of the 2 gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same 2 officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did, and I watched 2 other videos, which they fully got what they deserved. They broke the law unequivocally. But those 2 gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here. My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's not $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these 2 officers and other officers state, well, we don't have to do anything on private property. Well, this whole thing was on private property. The officer also stated that he observed me driving. That's a lie. Falsus in unum, falsus in omnibus, false in one thing, false in all. And if you begin it by a lie, how can you be credited to be believed at all?
And that is something that you would take up at trial in front of a jury, not at a pretrial conference.
So the officer stated that he had probable cause because he observed me driving. That's a lie. Jurisdiction, lies. You're an honorable man from what I've seen.
So where I was going with that is that, yes, I can provide you leniency, but I can't do it in such a way that it's detrimental to the other side.
Correct.
My side, I'm kind of like an umpire. I call balls and strikes, so to speak.
Correct.
So while, yes, I can give you leniency, I can't spoon feed you things as to what to say, what to file, that sort of thing. So I guess my next question is if I do allow you to represent yourself, would you be willing to have an attorney somewhat of counsel where they wouldn't necessarily be the attorney of record, but you would be able to talk to them about, proper, how to properly file something, how to, if you have any legal questions, how to, interpretation of the court rules, that type of thing. Is that something that you would be open to? So you would be representing yourself. You would just be able to rely on them as a reference.
The problem with that, sir, with all due respect, my wife and I asked Jockins for the supposed 14-second video of not our truck. Whether those are the victims or not, that wasn't my truck. In that 14-second video, that wasn't my truck. Now, I do not accept the fact that I had to watch it at the defender's office, and I still have been refused because policy and procedure, because others have put this stuff out on public notice. My wife has had her video of her accident because she had to take up the reins and take care of herself through her job. Nobody knows about that video. Nobody's seen that video. And most recently, we found out a bunch of other things. There's a conflict of interest. And the prosecution didn't say anything. My wife, who was ran over and her legs are destroyed, was made a victim. She's being made a victim again.
That's in this case?
Yes, sir.
All right.
She was removed as victim and placed as a witness.
So let me ask you, and I understand why we're getting a little heated, but
Sorry.
hold on, let me get my question out. So when you say you haven't been provided discovery, do you mean that it hasn't been physically handed to you, but you've had the opportunity to at least watch it?
Discovery, as I'm learning, is a multiplicity of things. And they have specific names.
So let me be more frank, because again, I'm on a time clock here.
Correct.
So let me just ask you, have you seen the video? Not has it been provided to you, but have you seen at least what they're saying is the video?
No.
Okay. Have you seen the police report?
Defender's office, while playing it, it stopped. There's an error. And the video was never allowed to be loaded back up and seen past a specific point, and it crashes every single time.
But they at least,
RJ stated, he's like, I just watched all of these. I don't understand what's going on.
but they at least attempted to play it for you and then it crashed,
I wasn't.
presumably.
Discovery means that the evidence goes to me.
No, I understand, but just focus on my question for a bit. My question is, were you given the opportunity to at least try to watch the video? I understand there were some technical issues, but did you at least,
Yes.
you were given that opportunity?
Yes.
And were you given the opportunity to review a police report? Maybe not handed, but did you at least, and don't talk about what they told you because I don't want to get into attorney-client privilege, but did you at least have the opportunity to generally say, okay, this is what the police report says, what do you say, and then kind of merge
I
the two?
object. The insinuation of attorney-client privilege against her, please.
Well, I have to be careful of that because I had appointed counsel.
Correct.
So I'm setting that aside right now. So at least by the time that you had counsel appointed, that's what I'm considering attorney-client privilege.
All right.
Not from here forward, just during that time period that you were with either Mr. Jockins or you were with Mr. Champion.
Yes.
Did you at least have the opportunity to go through a police report? Maybe not being handed to it or handed it.
We're given the addition to the police report. We were given the police report originally by Mr. Jockins,
Okay.
which at the bottom of the police report, and there's no signature of any witness. It was, Officer Dot, right?
All right, Mr. Leffers, I need you to focus on me because this is one of the rules of the court.
Yes.
It's not appropriate for you to be interacting with a member of the audience. And I realize that you're married and you're one, but
Memory.
yeah, I understand. And that's where why I have concerns about the memory aspect and allowing you to just represent yourself on your own. And that's one of the reasons I'd asked that question about whether you'd be open to of counsel situation where they're there for you to talk about the case. Sorry.
As long as it's completely, and if we have to sign an NDA, fine. I would prefer not to. I mean, I have nothing to hide. But if we have to sign a contract stating, I'm not contracting with this, my constitutional rights are broken. I know what lawyers are about. We've read it. Now, that's not saying everyone's that way because there's moral and honorable. But most of them just want that money. And I know where their allegiance lies, just like I didn't know that a judge also has a banker's oath. I didn't know any of that. But yes.
So, all right.
I will do my best.
So it sounds though that you want to represent yourself, but you're okay with having an of counsel position that you can talk with, make sure things are being filed properly and that sort of thing. Not that they're representing you, but just to be able to bounce ideas off, so to speak.
I reserve all rights through equity and trust law and under the Constitution.
And that is something that you would take up at trial in front of jury, not at a pretrial conference.
And as long as that's not violated, I don't have a problem with that.
All right.
That's what I'm saying. Now,
So if I allow you to represent yourself, are you going to be able, again, to comport yourself? Because realize that in the grand scheme of things, right? The Supreme Court's up here. I'm the district court. I'm way down here. There's lots of courts to get through before you get to the Supreme Court for appellate purposes. So a lot of the things that I'm left to decide are necessarily what the law says, what the Constitution says, the Constitution that is currently before me. There isn't, the appellate courts would have to tell me I'm wrong. Do you understand that?
sir, but we could read the Constitution.
No, I understand that, but what I'm saying,
Article 3, Section 2.
but what I'm saying is, because I've also noticed that in some pleadings, you said that you're not a 14th Amendment citizen, but hold on, but yeah, in the last pleading, you said I was violating your 14th Amendment.
It's a compilation of books.
Well, but
sir.
see, it can't be. So,
But it is,
but
actually.
see, that's where things kind of go off the rails, because you would agree with me, right? That if you are not a citizen of the United States, let's say you go to Japan, for example, all right? Are you not then subject to Japanese law if you're on their land? Whether or not you're a citizen, you would still be subject to Japanese law, correct?
No.
No, it's not an analysis. It's
It's
you
the
still
presumption.
retain your U.S. rights and citizenship, but the minute you would step into that territory of Japan, you're then subject to their laws.
Anything that abrogates the Constitution and its amendments is unlawful.
But the Constitution doesn't apply in Japan, right?
Well, it does. Because what national are you? That's also protected internationally to the international court.
This is a criminal case and has nothing to do with a trust or any equity. And since you brought up the Constitution, you might want to read up on the 10th Amendment, which delegates the police powers and jurisdictions to the states when it comes to most criminal matters.
Mr. Leffers, I will allow you to represent yourself, but I'm just forewarning you that you are going to be held to the same standards and procedures, whether or not you agree with those standards and procedures, because that is what I'm bound by. The standards and procedures that have been set by the Supreme Court, the laws of the state of Michigan. And when I say the Supreme Court, I mean both the Michigan Supreme Court and the United States Supreme Court. The laws of the state of Michigan and to the interpretations and case law of the when it comes in regards to interpretations of the U.S. Constitution and the Michigan Constitution. Now, I realize that because you've cited the 1850 Michigan Constitution. In this court's eyes, I believe it's the 1963 is the date. Don't hold me to that exact date, but the latest version of the Constitution. When citizens are able to pick and choose which things they agree with in the Constitution and which things they don't agree with the Constitution, that's where things run afoul. And that's where it takes a court a lot higher than me to make that decision. So it's a long-winded way of saying is I am only going to be bound by what is appropriate for this court. If you need to take it to higher courts, that's certainly your prerogative. But moving forward, can you at least agree to that?
Okay, so from what I remember is that the judge or the prosecutor, depending on how they file it, in which the prosecution filed it incorrectly, especially after finding out about my nationality status. Nationality status is protected by the Constitution, and the Supreme Court has ruled on that several times over. Now, the prosecuting office is supposed to refile the paperwork then and go for a grand jury indictment.
So there's a proper procedure in which you have to go through to do that. And this is not that proper procedure.
And if the prosecutor doesn't want to do that, then it falls upon you to make the decision. Where the truth is what it is. And Ezekiel 3:18-9. If we are seeing someone in sin and we don't say something, on the day of judgment, whatever you have seen, for anyone you didn't say something to, you will be judged for it. So, sir, I respect you and your honorable ways that I've seen. The Constitution and my rights are being broken and trampled on. My due process is broken. I cannot get an impartial anything in this county.
No, it's not. Underscore. I've been to Japan, and when you're in their country, you're required to follow Japanese laws, not American ones.
So what'll happen is if I allow you to represent yourself, you would then be able to file the demands for discovery, and the prosecutor would have to turn over to you what they have for discovery.
Well, it's not just that.
No, but I'm just saying, so that's one, that would alleviate one concern that you have.
Yes.
And then I understand
information to be executed and relieved over to me, which entail all of it. The financials, 12 bonds that have been
Well,
opened up.
so
The EE bonds,
they
the
can
I
only,
bonds,
so hold
the
on, so they
securitized.
can only provide what they have at their,
Anything
disposal.
that is charged.
they can only provide what they have at their disposal. They can't go out, or they're not required to go out and seek information that, let me rephrase that. They don't have to go out and generate discovery. If they don't have it, they don't have it. Does that make sense? So if they don't have a specific bond that you're requesting, they don't necessarily have to go out and get that bond. Do you understand that?
With the paperwork I filed, with the UCC laws on them, it clearly dictates and describes all the evidence that I'm asking for. Now, the amendment,
So, and this is where you get to step in as the lawyer. What authority do you have? What case law that do you have that says that the UCC applies in a Michigan state criminal charge?
the fact that it's tied to the case,
How?
because the bonds got opened up through the case number.
But
So the thing
So,
that's attached to.
where
the
do you
case
get that?
number
Where do you
is
get
my
that from?
Social security number. You can look it up on Treasury Direct.
But that's not my responsibility.
No, it's not.
So-
In due diligence and learning, we started looking. Multiple friends are helping. So they're pointing us in the right direction. So we have literally seen it, we have photographed it. Over 12 bonds have been opened up with a numerical value over $500,000. As of right now, over $500,000 in EE bonds and I bonds have been opened up off of this case. The only thing attached to this case is my social security number, which my estate owns.
So who opened the bonds?
Well, I would have to be given time to file the paperwork, which I've already been filing. I've already filed with the Trade Commission on the fraud that I did not authorize these, and I want to see the wet ink signatures. I also filed for the fiduciary change to Treasury Secretary. The ID will be coming back. That was wonderful, because there's a few documents that I have to scan my ID for before I can submit them to the state to continue moving through for my nationality status in whole.
And who do you apply to for your nationality status in whole? Because you were
Well, it's actually
born
a lot of stuff. A
You were-
lot of stuff. You gotta set the IRS correct. You gotta set the Treasury Secretary correct. I gotta send a letter to the governor. I gotta send a letter to the head sheriffs. And like when we lived in Alabama, it was a sheriff's director board or whatever. They had a meeting every week.
Ah, that's cute. You're not getting your way. So you think it's an inability to be an impartial issue, when in reality, it's not wanting to follow the laws of the city, county, and state that you're an issue.
I'd have to send a letter of notification of the revocation of the driver's license and driving privately. And already switching over the titles to the trust, just running low on equity. Which is why the other reason, her case is tied to mine. Misconduct. They removed her as the victim. She can't use her legs properly. And she's doing the best she can. We would both be working. I had to stop working because my foreman found out about my CSC, and he tried to squish me with 6,000 pounds of steel that I just got done welding up. That was the second job. That was DCL, Traverse City. Before that, it was Stage Right out of Clare. They loved me so much, they didn't want me going to third. They offered me first after I got out of the temp service, because I got into the temp service because I have documentation from the SOARS department stating you don't have to register because you are not a Michigan resident. We support jurisdiction and constitution. But once you sell your house and you're no longer domiciled in Adams County, Illinois, you have to get a Michigan license. So I registered in the private and have registered in the private of my own free will and volition to prove I am not a threat to a community. That if there ever is a problem, you can call me up, because the only ones that can see me are y'all.
What do you mean by that?
When we moved down to Illinois, they sent a letter. They never would have prosecuted me. They never would have charged me. Here's a letter stating that as long as you're an Illinois resident, you will never have to register another day in your life. Wow. I was able to hold the job for 13 years. Didn't get pushed off, didn't get hit, didn't have people trying to kill me. That's why we left Michigan. And it went to our children in public school. They were tormented, tortured. But I have documentation proving all the way from Ottawa County, Ottawa, Granville, Grand Rapids, Mecosta, stating I didn't have to register. And I am doing it of my own free volition to protect those that might think nefarious ideas about.
Who else isn't surprised that he's from Alabama? I'm sure his sister cousin wife isn't surprised either.
So because I noticed one of the pleadings that you filed before, you mentioned that you were I think you said you were a resident of Kent County?
Yes, sir. That's our in care of address.
Okay. All right. Now, so when you said that we're the only ones that are able to see you, are you talking about because of the registry?
Oh, no, that's been changed since I sold my house.
Okay.
The house was locked up for about 2 years because the neighbors were so bad. Liquid Drano bombs over the house, attempted arson of the house. Yeah, and we homeschooled.
So when you said that we're the only one able to see you, I guess I need
Well,
some more
now-
no, hold on. I need some more clarification. What did you mean by we're the only ones who are able to see you?
Okay, so the SOARS department,
Okay.
when we first came back to Michigan, I contacted them. They said, well, we're going to have to look into this. We don't really know what to do. So they got back with me, stated, you don't have to do anything. Like, what do you mean? Like, you don't have to register. You don't have to notify anybody anywhere you go in the state of Michigan. You're not a Michigan resident.
Okay.
I'm like, okay, but I was charged in Michigan way back then. And I don't want anyone thinking anything wrong. The SARS department flat out stated, look, if you want to register, you can. We will keep you in the private registry section. We're the only ones that will see you are law enforcement. It's like,
Okay.
that's
So
it.
I know
Okay,
what you
I'll
mean.
do that.
Okay. All right.
So SOARS department and I, when I went to Ottawa County, Fillmore County Complex, they're like, wait, what's going on? You're not a sex offender. I'm like, no, I'm not.
So they were going to register
They
you.
didn't know what to do. They had to get on the phone with the SOARS department. I was in that waiting room over an hour and a half, allowing them time to get everything situated. And then I willfully went on the sex offender registry that I didn't have to do because the SOARS Department of Michigan respects jurisdiction and constitution.
All right. All right, Mr. Leffers, I am going to allow you to represent yourself. Again, we've got an understanding that you're going to do the best that you can to be compliant with the court rules. Also, I'll allow the public defender's office to remain on as of counsel so that you can reach out to them. Not saying that they're going to represent you, but they're going to be there for a resource for you. Okay? And so that means from here on out, you're going to be able to represent yourself and you're going to be held to the same standards as we discussed. And I can give you some leniency, but not a ton.
I gotta let you know though, this can't proceed. I cannot be a part of fraud.
But so Mr. Leffers, this is where we get into the procedural aspect of it. This is where you will be able to file motions. You'll be able to conduct the hearing. And then that's where you'll be asking me to make a determination as to whether or not the case goes forward. but understand there's only certain ways that that can be done in a criminal matter. So just because you stand here today and asking for that, what I have is your word, but the prosecution doesn't have the ability to put anybody on to contradict your word. And so we would have to have an evidentiary hearing, which is essentially what the preliminary examination would be for. And that is, and that's the next step in the proceed. Well, actually, the next step would be for you to meet with the prosecutors, see if there was a way to resolve the case, which I understand if you don't want to. And then the next step after that would be what we call the preliminary examination. And that's where witnesses would take the stand. They would testify. You would have the ability to cross-examine those witnesses. You would have the ability to call your own witnesses. The prosecution can examine your witnesses or cross-examine your witnesses. And then you can make your argument then as to whether or not it's whatever the arguments you want to make as to whether or not the case should be dismissed. Today's not that proper time. That proper time is you're gonna get it, but it's gonna be at some different point in the future. Do you understand that?
Yes, sir.
All right.
May I say one last thing?
Yes.
Victoria incumbent onus from Bondi. The burden of proof is on the plaintiff that originally brought the charges.
That's correct. And when I say that you get to make an argument, you don't have to present any evidence. They can get up there and put on their witness, and you can argue as to why I should or should not move the case forward.
Okay. In the I need to be allowed full access to everything. Not, well, set up an appointment. I get up at 2 a.m. I go to bed at like 12:30 at night.
For those that didn't hear that too well, he's talking about having to defend himself against people who have various ideas about him. What he's referring to is the fact that he's a convicted sex offender that's required to register in every state that he moves to.
So I have a lot of time on my hands.
So what'll happen
I need time
is
to look at things
you'll-
and having to set up
an
appointment.
So there won't necessarily be an appointment with the prosecutor's office. What'll happen, and
Well, no,
now it's been
prosecutor's
a
office.
while, hold on. It's been a while since I've been there, and this is part of the procedural aspect of this. You will have to file a demand for discovery. All right. You'll have to file that with the prosecutor. Now that you are going to be representing yourself, you would file a demand for discovery with the prosecutor's office. Outline everything that you want them to produce, understanding that they only have to produce what they have in their records. They don't have to go out and find things to help substantiate your case, right?
Correct.
Now, they do have a certain amount of time in which to do that with. So it's not like you can file today and request it tomorrow. They've got a reasonable amount of time, which the Michigan Supreme Court has decided is 21 days to comply with that request.
Okay, that was a quandary that we came across. We've seen 5 days, 7 days, 21 days. We couldn't exactly pinpoint anything for sure. So thank you for clarifying.
So yes,
that.
the Michigan rules of criminal procedure adopted by the Michigan Supreme Court says that they have 21 days to comply. If they don't comply within that 21-day period, then there's other avenues that you have to either force compliance, or if it's such a out disregard for the rule, it could result in a dismissal of the case. That's a very extreme based on just discovery, but that is a potential outcome there.
Okay, and all the times before this don't matter.
So all the times before, you were represented by counsel. So those requests would have had to have come through counsel, which is how Mr. Champion got it and how Mr. Jockins got it.
But that goes against what I was stating, and I objected to it.
I understand that, but again, that goes into the procedures that the Michigan Supreme Court have set up for the courts to follow. But now that you're representing yourself, you are in a completely different place than you were before.
May I be candid?
Sure.
So does that mean that all of the court dates up until now was the inquiry competency test?
No, nobody,
Just a-
nobody,
I agree.
no, nobody has requested competency on you. Well,
No,
Mr.
no.
Jockins did, but we
Yeah,
didn't even get to that
whatever.
point. Yep. No, what this,
Meaning,
what we've been doing is I want to make sure, because as I said, I'm the independent party here. I want to make sure that your rights are protected, that you're getting the adequate representation and the right information that you need in order to make sure that your rights are protected. Now, I understand that you might not agree with some of those procedures and it might not be moving as fast as you wanted it to, but that is why I had, I don't remember whether I had appointed or requested Mr. Jockins an appointment for him, but I know I specifically, when we removed him from the case, I do specifically remember requesting another appointment of an attorney. Because again, once you step into the role of representing yourself, that puts you at a whole different level as far as compliance with court rules, procedures, appellate rights, as opposed to having representation. So I wanted to make sure that you had every available opportunity to you. Now, all these dates that you've had, they all go to what we call the speedy trial clock. So because you are charged with a felony, you have to be, because you're not in custody, it's a little bit different. But we all look at the speedy trial clock as being 180 days before you should be at trial. All right, because you're not in custody, there's some grace given to that. But all of these then look at whether or not who these delays should be accounted against. So all these dates you've had were not in vain. They're one to make sure that you're getting the appropriate representation, and they will be considered when it comes time to a speedy trial clock decision, if you get to that point. You may prevail at preliminary examination. We don't have to worry about speedy trial.
how did, in reading, if I agree, then that means I'm ignoring all of the past times. That the things I've stated about the Constitution, Article 3, Section 2, Clause 2, are being ignored, and I'm okay with that. I'm not okay with that.
Hey, like I said, if the court truly doesn't have any jurisdiction over you, then just do what I would do and leave. I mean, if you're right, then they couldn't do anything to stop you. But if you're wrong, which you know you are, then you should probably just take the free lawyer that's being offered to you and quit listening to the bad advice that you and your wife are getting off the internet.
You're not saying that you're okay with that. What you're doing is you're going to get your opportunity to raise those issues. It's just not right now. It's going to be at a point, a couple dates down the road.
All right.
Okay?
I object to all of it,
All right, I'll note your objection.
but if I have to go through this, fine.
So I'll note your objection. I'll allow you to represent yourself. The public defender's office will remain on in of counsel capacity. We will reset this then for a probable cause conference. Now, the other issue, hold on. The other issue is you had also filed a motion to set aside a default.
Yes, sir.
There has been no default judgments entered. So
That came in the mail. We didn't know what the heck was going on, no offense.
what came in? Was there a civil infraction with this?
Yes. It was slipped in when I left. I didn't fully
yes.
grasp.
There is a civil infraction?
It's a fail to pay booking fee.
All right, so
Sir,
I will grant that request.
Got an object to it though.
Yep, go ahead and object.
Sorry. My wife and I went in on a Saturday before I went and worked with Bob, Travis's cousin. And the gentleman on the phone said that the booking fee was $12 and you could pay it at the kiosk 24/7. So we went in and we paid the $12 and it apparently still stated that monies was owed, fiat was owed to the kiosk, which didn't make any sense unless all the dumping of whatever charges were added on. But we have the receipt for the $12 of the booking fee that we were informed personally on the phone from a Wexford County officer. And the website also says that it's a $12 booking fee. Then I got that in the mail. This is preposterous. This is nonsense.
All right, so what I'm going to do is I will set aside that default. And
Thank you,
then
sir.
we can deal with that in a normal course of business in regards to that.
Thank you, sir.
All right, so Mr. Leffers, you can go out to the front window where you checked in. Is there somebody out there to give him a court date?
Yeah.
And get your next court date, okay?
Yes, can we speak about that, please?
Yes, very briefly, because I'm
When-
now an
when are
hour
you
behind.
thinking?
So my thought is PCC would be reset for next Tuesday. Will that work for you or no?
Honestly, no.
Okay, so will the following Tuesday, which would be the 19th, will that work? Go ahead.
I need. It's not on the doctor's. 19th would be fine.
Okay, so we will reset it for the 19th. That will give you time to get discovery requests to the prosecutor. And it'll be set for 10:30 on the 19th.
Now, this means that I will be able to have all the discovery within my.
So remember, they've got 21 days to comply, but my guess is since they provided it to two different attorneys, they can probably get it to you within a 2-week time period.
Well, no, I'm not
So-
talking about the time frame, sir. What I mean is the actual tangible, me being able to download all these
Yeah,
videos
so-
on my phones. It's not going public.
So,
Okay, it's not going public.
So what'll happen, I don't know how it works anymore in their office, but they'll either provide you a link to click on, or you'll get a CD to put into a computer. However they do it, that's how you'll receive it. I think they do it by link now, where you'll be able to click a link and download it, but don't hold me to that.
Now,
But you can talk with the prosecutor's office about the best way to get it to you.
now, there's a discernment with that one. If it's a link to a video, how am I supposed to make sure that that thing hasn't been doctored up or anything?
Well, that's where you as your attorney get to figure that out.
Unfortunately, I don't have the accessibility of resources at my hands as a prosecutor does. So if I were to want to have a video authenticated.
You wanted to represent yourself, so figure it out. Or just take the lawyer and let him figure it out for you.
So there's a process. So the court is no longer involved with appointing expert witnesses. Because you are indigent, you would have to then request through the public defender's office, which they're going to be of counsel, to see whether or not they have any funds available to hire an expert on your behalf. I'm not saying that they will. I'm not saying that they won't. I don't know, because they're their own independent office. But that's where your of counsel attorney is going to come in and maybe give you some guidance there. Okay.
Yeah, I object to all of this.
I understand, and I know your objection.
Constitutional rights been broken, man.
I know, but there's just because you think it has been, and I'm not saying that you're wrong. Please don't take it that way. But the prosecution has the ability to defend their case, and today is not that day. That day's coming. It's coming. I promise you that, but it's not here yet. Okay, so just bear with us a little bit.
Yes, sir.
All right. I thank you for your patience today and your cooperation. You can go out to the front window where you checked in.
All right, so that's the end of the video. He has an upcoming court date, and I'll definitely be there to laugh at the sex pest some more. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Court News, and I'm out. Did we go?